Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Hello, and welcome to this episode of Resolution, a podcast about dispute resolution and prevention. My name is Rekha Rangachari, one of the handful of hosts interviewing colleagues and friends about cutting-edge issues in our practice. I am thrilled to have on the line today Amy Schmitz. Before I bring Amy on, though, let me offer her bio to you. Amy is the John Deaver Drinko-Baker and Hostetler Endowed Chair in the law at Ohio State University Moritz College of Law. She serves as co-director of the Translational Data Analytics Institute Responsible Data Science Community of Practice. Amy, you're going to have to break everything down for us later. It's a phenomenal bio. And director of the Justice Tech Capstone and Fellowship Program, while also working with the programs on dispute resolution, data governance, and the Divided Community Project. A distinguished scholar, Amy has published over 75 articles in law journals and numerous books. Amy has been awarded a 2024-2025 Fulbright U.S. Specialist Award to examine access to justice in the AI and digital era in Granada, Spain. Amy is a second-time recipient of this award, her first focused on researching and collaborating on AI, data analytics, and the law in the Netherlands. Amy's newest work, which we discuss in this podcast, is an interview series titled The Arbitration Conversation. It began as a highly regarded podcast, over 115 interviews, translated this year into an ABA dispute resolution section publication, where Amy discusses latest developments in arbitration with top global scholars and practitioners. With that, Amy, welcome to the stage.
Thank you so much. I'm really looking forward to talking with you.
So we're going to jump right in, and we begin at the 2020 marker, when we saw the world go into the grips of pandemic, reaching closures of all kinds, including borders and courts, and as we tried to dig deep and figure out what comes next. The arbitration conversation was born during this time, and as you know, it was a means of making lemonade from lemons. So as we dive in, you document in your book the move to online arbitrations, OARB, and investigate firsthand what was working, not working, and issues to explore. The pandemic arguably offered the best marketing for ADR against national court closures, but there had to be the foresight on the ground and in real time in 2020 to embrace two characteristics you deal with in the text and interviews: adaptability and problem solving. What do these words mean to you and in the larger context of dispute resolution design, including, if you're willing, a discussion on AI? Was there resistance to OARB at the beginning?
Yeah, no, thank you so much. It's such an important question. And I have to say, it was kind of amazing to be sort of right in the middle of it, right in the thick of it. Backing up, I had actually written and I looked at ways that we could be using more video many years ago. I had written an article, Drive-by Arbitration, the Digital Age, really a long time ago, about how we could use more technology in arbitration, but there was a lot of resistance and people sort of wondered no, that's not possible. We need the empathy. We need to be able to look at credibility. We have to be in person. And so there was a lot of resistance. And even back when I was in private practice, certainly video was really not considered to be, that was not as really legitimate as an in-person hearing. So then, fast forward to 2020, and here we are, like you said, everything's shut down. Suddenly people had to try it. They had to adapt. And one of the really sort of most interesting and important pieces when we think about dispute prevention and resolution is to think about all the tools that we have in our problem-solving toolbox. And at the time, and as dispute resolution people, right, we have to be problem solvers. If somebody comes to us with a dispute, and we're trying to help them solve a problem, right? And so I think what was really amazing with the pandemic shutdown, certainly there were horrific and awful things, but one thing we did see is sort of human ingenuity and problem solving, and we had to use video, and people learned how to use it out of necessity, and then realized, you know what, it's not so bad. This is helpful. I am saving money. I don't have to travel. But also really people did become more expert in something that they originally thought, oh no, this is never going to work. So there was resistance in the beginning, but I think as time went on, more and more individuals were moving toward it. And it was very, very interesting in the interviews, often in the pre-interview, right? When you're talking to all these scholars and arbitrators and experts in the field, and they would all be sharing their journey about sort of realizing how you could use technology as a problem-solving tool at the time.
And Amy, here, I just wanted to take a minute because we're constantly problem solving, we're constantly adapting, we're constantly, hopefully, developing human ingenuity. And so how does that apply looking forward to what we might be doing with AI and issues therein, and taking people along who may be dragging their feet in a similar modality of what happened in 2020 when people said, what do you mean you want me to turn my video on and run a hearing? What does that entail?
Right, right. Yeah. I mean, I think, first of all, adaptability, right? Also, kind of coming up with a plan and thinking it through. I mean, we've all seen now, even in large scale, complex commercial arbitration, you see use of video, maybe for particular witnesses. Maybe it's a hybrid hearing. Here are ways that we can help with scheduling issues. Maybe everyone can't travel, but some will. Maybe the parties and their attorneys are there, but not everybody else. We're seeing this sort of adaptability, which I think is very interesting, even going forward, even when people are able to travel, but also these uses of different technologies. Again, you asked earlier about system design, and I am a huge proponent of being intentional, like really thinking through the various technology, including AI, including these new tools that are coming down the pipeline. How can we use them in a responsible and intentional manner in order to really solve problems, not create problems? I always say, you don't use a hammer when you need a screwdriver, right? So you don't use ChatGPT to cite cases, which we all know. But there are different technologies now, though, that I think are becoming more and more sophisticated, and such things as retrieval augmented generation and new technologies that are coming down the pipeline that can be very helpful for parties and for neutrals.
That's really useful. And I'm sure more to come on that. Do stay tuned, as we mentioned, because Amy will be delving deep into this in Granada, Spain, for her access to justice in AI and the digital era. So more to come. But back to arbitration conversation. So in chapter 3, you get into a discussion about 3 niche and distinct areas of the law: employment, consumer, and international arbitration. And you underscore them or tether them together by this phrase, context matters. So tell us, how do these distinct areas within dispute resolution work together, come together, have some sort of similarity of context?
Yeah. So first of all, I do believe context is very important. When we think about dispute prevention and resolution, when we think about really fitting, they talk a lot in dispute resolution about fitting the forum to the fuss. But I think we have to really think about all of the different pieces and what makes sense for a particular case. And therefore, context really does matter. Who are the people and what is the problem that you're addressing? But at the same time, there are through lines, right? So it's a bit of whiplash, right? Somebody can open up and look at chapter 3 and say, well, why would you ever put employment and consumer in the same bucket in the same chapter with international? Well, partly to show how starkly different they are. I mean, as we were talking about before taping, certainly the laws around the enforcement of pre-dispute arbitration are dramatically different in different parts of the world. I remember writing an article many years ago about American exceptionalism when it comes to consumer arbitration, for example. And so a lot of these concepts in consumer and employment that are very normal within the US are not normal in other parts of the world. But at the same time, we are seeing more international consumer cases, international aspects being brought in to all these different areas of the law. So on the one hand, we tend to be very siloed when we think about these different areas of arbitration, but at the same time, there are through lines and there are lessons learned. That said, I think it is tremendously important for practitioners, for attorneys, for everyone involved in the arbitration world to be aware of the specific context. We're seeing this now, for example, with mass arbitration, where you have large law firms involved wanting to really sort of bring in all the commercial rules, even though they're under the consumer rules, for example, which are very different from the commercial rules with the American Arbitration Association, for example. So I think, there's lessons learned there. And it was especially important for me to interview these various arbitrators who maybe only work in the consumer space, others that work in all of the above. And like I said earlier, that we are seeing more now in the mass arbitration, where there's many arbitrations filed against the same respondent in the consumer context, and sometimes it even does involve international.
It's important, I think, also to note here, we're in an era of an abundance of rules across arbitral institutions, the newest of which perhaps is this introduction, as you mentioned, of mass arbitration rules to add to the tapestry of what's possible for people to use to bring claims. And so just because there are so many offerings like in Starbucks doesn't mean we need to use every single option, but the truth is that they're there so that we can try to get better at the practice of dispute resolution, towards those words we use often like economy and efficiency. And hopefully that's the case. I also wanted to note here these through lines. What's important about Amy's text, Arbitration Conversation, is that indeed you could read it chapter to chapter and pull through that way. But you could also, as I did in some instances, pull out a chapter, just start reading there. And it's a chapter unto itself. You can deal with that chapter on its own. And so however you like to read, do give it a shot in any modicum.
Yeah, I have to say,
yeah, Amy,
no,
please.
thank you for that, because I have to say, so I cannot tell you how many times over and over dissecting and listening to all of these interviews and then really thinking it through. And so when I put together the table of contents, and when it was very intentional, each chapter, in terms of the main lesson learned. And so I thank you for that, because I really did see some themes. It was really quite amazing how the themes did sort of jump out at me after I listened to all the interviews many times.
I think that's important to our readers. So when you pick this up, and it's not a mighty one that you can, do some curls with, but really it's something you can slip in your bag and take through on your various transit lines and get into it. And so with that, we'll get into it further with Amy. We're going to go into next. There's a discussion within the book about a dedication to diversity. Amy and I were discussing how diversity has become a hot button topic. It's added to every conference as a panel. But the tough questions are not only diagnosing where are we now through the interviews you've had, but where are we headed? How do we deal with the new voices and giving them traction? And I'm curious to hear your thoughts on these, Amy.
Yeah, no, I mean, I get concerned that it becomes sort of a check the box type activity, right? You can say, well, we're including this percentage on our panel, right? And then that somehow is good enough, or that's going to really make a difference. But often it really doesn't make a difference in terms of who's actually selected and who is able to make a living or be more involved in the arbitration space, especially in commercial arbitration. We do see greater sort of attention and just a wider range of individuals in some areas, but I do think commercial is difficult. It's difficult to crack in as a newcomer. I think it's important for us to not just sort of check boxes or be so granular in what we think about as diversity, and really be more all-encompassing. And that was another theme I really did sort of learn in talking to different individuals about this topic. And certainly some of the interviewees were quite not very optimistic in terms of where we are currently. Absolutely, some of the interviews were pretty concerned that there really has not been a whole lot of change that has occurred in terms of real numbers, in terms of who is actually selected. But I also think it's important, again, getting back to just this broader idea of new voices and new individuals and younger individuals having opportunities to get involved in arbitration. That can be a very, very difficult to kind of break in.
It's an important point about how we get to spotlight the new voices, but also that, this is a data-driven conversation, but it only gets somewhere with the candor of the human story. That's the truth. These experiences, then we pull people's different ones together and we see How have they experienced the practice in this jurisdiction as against that? Are there similarities and differences? What are they? But then how do we push forward? So it's a lot of food for thought there, and really a big thanks to those that you interviewed that were candid about those experiences to push us farther.
Yeah, yeah, and it is a very human story, and that's the other thing with the whole idea with the arbitration conversation is you end up having just very interesting conversations and people telling their stories, and that in and of itself, I think, can be very powerful.
Hugely so. Right here, I wanted to just note, if you're looking for the vocals of the arbitration conversation, the actual interviews, which will be in the blurb, arbitrate.com is one place where you can find them, but more on this within the text of the podcast. So our next topic, we'll conclude on this substantive topic before a fun question. I want to get into briefly the special symposium chapter you have discussing SCOTUS 2022 and its coverage, where the Supreme Court of the United States is taking us, what are lessons learned, and the truth is we're now in 2024 recording. What are lessons we're still learning? How is the court composition changing the way we look at the text?
Yeah, this is really interesting. Of course, because of the timing of when the interviews were happening, we did do a special symposium on 2022, but in that, and by the way, that year there were even more than, we always get arbitration cases that go to the Supreme Court, but I would say that was a pretty heavy year in terms of the number of cases and wide variety of topics. But what we're seeing, and especially going forward, and I do have the other casebook with Tom Stepanowicz in arbitration and like to keep very up to date on the law. And it is very interesting to watch the opinions. They're very specific, very textual, not necessarily just pro arbitration. For a while there was kind of this idea, oh, well, pro business, pro arbitration, but I don't think it's that simple anymore. I think for anyone who is following the law, you have to really look at the text of the Federal Arbitration Act, which is somewhat, funny if you think about it, because that was written in 1925, right? We're coming upon the 100th anniversary of the Federal Arbitration Act, and it's a very short law. So it doesn't really have a whole lot of specifics, but yet you see the US Supreme Court really focusing on the specific language. And that also makes it difficult for practitioners to predict the next outcome, right? Because they're not really sort of issuing rulings that help clarify for us things like the transportation worker exemption, right? So we're seeing these very, very discrete opinions that leave questions and really don't answer any particular area. And so it's somewhat ambiguous, but yet we know it's textual, I believe.
That's very helpful. Thank you. And so there's a lot more to say, of course, on the Supreme Court to our listeners, and we're thoughtful that we do not have the bandwidth now to get into it. Amy has spoken a lot about this on different mediums, so please do tune into those if you're curious. And of course, take a look at that specific chapter holding the symposium and taking stock of 2022. So we're going to end here with, we've been talking about things like system design and intentionality, and the composition of a book is always important. Where there is an epigraph, it directs us to what the author is thinking about. And Amy's epigraph reads, "For my sisters who share my love for teaching, learning, and great conversation." Storytelling can be something we learn from a young age in the household, amidst our family, as we encourage one another. So I want you to tell us a bit more about this epigraph and about your sisters and the bond.
Oh, thank you so much. Yeah, I mean, again, during the same time, some people were baking bread. I was talking with people on Zoom, right, for my podcast, but also to my sisters. It was really a lifeline for me, and we would have sister meetings where my sisters and I have two sisters. They're both public educators. I'm so proud of them out there on the front lines. One teaches literacy, the other teaches in the high school, public schools. And, we would talk and just share stories, and it was very comforting and very important for me. And we really do share a love for learning and teaching and just telling stories. And sometimes we would end up on Zoom for 2 hours just sharing stories about our lives and things that were happening on a daily basis. And it really was a lifeline. So it's very important to me, and I definitely dedicate this project and the book to my sisters.
It's true that the pandemic from which this book was born taught us a lot about how we maintain human lifelines when we don't always get the luxury to see one another. And so it's great to be out of that period of lockdown. To those tuning in, we've just been talking with Amy Schmitz about the Arbitration Conversation, insights and wisdom from experts in the field, compiling the interviews that she did over a period of time, over 100 interviews, and just codifying it into a book. Amy, it has been such a pleasure to get this brief moment in time to sit down with you. Thank you so much for coming on the podcast.
Oh, the pleasure is entirely mine. Thank you so much. I really appreciate your work on this, on your project, on your podcast, in teasing out individual stories and talking with us in the field. So thank you very much.
Marvelous. Well, to Amy, thanks so much. To our listeners, stay tuned. There's more to come. Have a great day.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.